A very good evening, ladies and gentlemen. I'm pleased to welcome you all to the 78th webinar and episode 35 of the Basics of Law webinar series organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. At the outset, I wish to extend my sincere appreciation to the President of the Bar Association of Sri Lanka, the Chairman of the Webinars and Legal Symposiums Committee, and the Co-Chairman, the Secretary Treasurer of the BSL, as well as the convenes, co-convenes, and the members of the committee, for their continued commitment in organizing this valuable educational initiative. I also take this opportunity to thank the Executive Committee of the BSL for their guidance and support. For today's session, under the Basics of Law series, we are honored to have with us Dr. Ramindranath Dabre, attorney at law, who will be delivering the lecture on law of air pollution. Dr. Ramindranath Dabre serves as the chair of the BSL Environmental Standing Committee. He is a founding member and a senior advisor of the Center for Environmental Justice and a member of the Environmental Law Alliance Worldwide. He has also served as a member of the ministerial subcommittee appointed to amend the laws relating to sound pollution, and also is a former advisor to the Ministry of Environment. It is indeed a privilege to have Dr. Ramindranath Dabre with us today, and I warmly welcome him to this session. To moderate today's proceedings, we are pleased to have with us Mr. Theekshana Patirana, attorney at law. Mr. Patirana specializes in civil litigation, commercial law, and corporate transactional law, and regularly appears in appellate courts handling writ and fundamental right matters. He holds an LLB from the University of Staffordshire, United Kingdom, and an LLM from the University of Colombo. With a focus on constitutional and administrative law, he's commenced his career as a Secretary of Justice of the Supreme Court and has since represented clients in complex, white-collar, family, and commercial matters, including appearances on behalf of leading financial institutions of Sri Lanka. I warmly welcome Mr. Theekshana Patirana and invite him to moderate today's session. Without any further ado, I now invite him to commence the proceedings. Thank you.
Thank you, Rochelle. Thank you. I wish all of our participants a very good evening. And we have with us on board none other than the esteemed practitioner who's widely known to be a fierce fighter in environmental law and related justice, Dr. Dabre. And I would like to invite him to be the panelist in this session. And before that, I would like to add something in connection to this webinar, which is of a timely necessity, I would say. When it comes to environmental law, and in particular law of air pollution, one would wonder as to what would be the place it holds in the hierarchy of law. I would say, and I'm sure Dr. Dabre would correct me if I'm wrong, that law of air pollution within the umbrella of environmental law plays a vital role. For an example, if you look at the recent data when it comes to our neighbor India, where the World Health Organization has recognized it to be 5 microgram per cubic meter to be the healthy level when it comes to air quality. We've got reports where in India, it is of course 10 times higher than that 50 micrograms per cubic meter. And in particular in New Delhi, it has gone up to as high as 250. So with that, for an example, with the research conducted by University of Chicago, it has concluded that with that level of pollution, air pollution, the life expectancy would be reduced by 3.5 to 4 years. So with that in our mind, with the idea that law of air pollution would be as important as all the other areas of law, I would like to invite Dr. Dabre to facilitate all our viewers with his immense knowledge in this area, who's a fierce fighter, who has got both theoretical and practical expertise. Doctor, the floor is yours.
Thank you, Tikshana. There is a small issue with my normal equipment. I don't know whether I am audible. Tikshana, I can't hear you, Tikshana.
We can hear you very well, Doctor.
Yeah,
you can go. Proceed.
Yeah, because there was some technical issue. Anyway, thank you very much, Tikshana, and all organizers who organized this webinar, and especially I must thank the president of the Bar Association, secretary, and the office bearers, and all organizers, including Tikshana, for inviting me and giving me this opportunity to deal with this important issue. Tikshana, my problem is, although I have prepared a PowerPoint, I don't know whether I can share it. I will try to share it. Because this equipment is not familiar to me. There was some issue with my normal. Sorry, unfortunately, I will go ahead without the PowerPoint presentation.
I'm sure,
Now,
Doctor, even without that, you would make it look far better than even with the presentation. So we don't have any problem with or without it. You can proceed, Doctor.
right, thank you. And we know that air pollution is one of the important problems faced by we all nowadays. Especially air pollution is defined in Sri Lankan context under the National Environment Act, Section 23K1 of the National Environment Act. Air pollution is very clearly defined. So, and if I am to read it out, air pollution is defined as any alteration of the physical, technical, chemical, or biological condition of the atmosphere, rendering it unclean, noxious, poisonous, or otherwise harmful, or detrimental to human health. So that is how it is defined. Shall I try once again to open this? Give me at least 1 minute. Sorry, there is a problem still. I can't get it corrected. Then under the National Environment Act, there are some penalties imposed if any air pollution is committed by any person, and the fines and daily penalties are also imposed. There is a fine ranging from 10,000 to 100,000, and if the activity which creates the pollution is to be continued, then there is a daily fine of 500 rupees. And the court can require the offender to take corrective actions or to prevent further pollution. And even the recovery of the cost is also can be done through the courts, that is polluter pays principle under the air pollution laws of the country. Then the penalties and enforcement for air pollution under the National Environment Act can even extend to closure of factories or trade or businesses if air pollution is continued more than 6 weeks after the conviction. Even the court can issue closure orders. That means orders to close the factories or close the source. And non-compliance with the closure order will lead to magistrate to utilize the authorities such as fiscal or police to close the premise. Then there are some international conventions signed by Sri Lanka to address air pollution, such as Stockholm Convention on Persisted Organic Pollutants, that is POPs, and MARPOL, Minamata Convention, Vienna Convention. In addition to that, UN Framework Convention on Climate Change is also one of the important international instruments signed by, or convention signed by this country, which compulsory for us to, or our state to mitigate air pollution. And under these international conventions signed by us, there are some local legislation such as National Environment Act. I already discussed the relevant provision in the National Environment Act. And then international conventions also integrated into some policy document, such as Sri Lankan Clean Air Action Plan 2025. In addition to that, there are some regulations issued under the National Environment Act. Those are National Environmental Protection and Quality Regulations, number 1 of 2008, published in the Gazette Extraordinary of the Democratic Socialist Republic of Sri Lanka. Then there are some regulations which prohibit discharging or emitting waste into the environmental without an environmental protection license. Then Form A is that is the Schedule 2. Section 5 gives the form which deals with the atmospheric emission and requires license applicants to be license to be obtained by the applicants. And the there is another Form B which is described under Schedule 2. In addition to that, Regulation 3 allows the Central Environment Authority to impose stricter standards than those in Schedule, where we are needed to protect the receiving environment if the Central Environmental Authority thinks fit to do so. Then in addition to that, there are a number of pollutants, especially the particulate matters. The particulate matters are also identified as one of the main pollutants, in addition to the gases or different gaseous formulas. Those are particulate matter 10 and PM 2.5, that is particulate matter 2.5. That is those 10 and 2.5 is these numbers are given according to the diameter of the particles. And according to the Sri Lankan legal standard, maximum permissible level is 50 for the PM10, that is particulated matter 10, that is for maximum permissible level annual. But maximum permissible level for 24 hours is 100 according to the Sri Lankan standard. But according to the WHO standard, these standards are very low. And Sri Lanka is still using the 2008 Gazette. But after the 2008 Gazette, we have not amended the laws to be incompatible with the WHO standards. Then there is a national action plan also for the air pollution mitigation, that is Clean Air Action Plan. I referred it to earlier also. Those action plans are prepared to be in line with the international conventions signed by the country, especially to establish a national coordination platform for air quality management and to identify, monitor, and reduce sources of air pollutants and strengthen laws, regulations, and enforcement mechanisms. I think even many of us are not aware of this Clean Air Action Plan. It is actually operative from 2025. It is a binding action plan. Even all state authorities, institutes, and even the public are bound to adhere to this action plan. And there are key air pollution mitigation sectors identified under the National Action Plan. Those are transport sector, industry, indoor air pollution management, and control of open burning and waste burning, and promotion of cleaner technologies and fuels. Those are some of the strategies undertaken by the government to be incompatible with the international requirements and the international guidelines. And there is a air resource management center, we known as ARMEC, with multiple ministries and agencies as the stakeholder. Its duty is to review, monitor, and update every 2 years the regulatory methods and the regulatory tools relating to the air quality monitoring and the governance. And even the public education and awareness programs to change behavior, also one of the main targets and main ingredients of the action plan. And WHO, that is World Health Organization, also annually issues air quality deadlines or air quality guidelines actually, or standards. Those standards should be adhered by the country. But as a country, we have failed to comply with the WHO air quality guidelines. That is, as I told you, the PM 2.5 and PM 10, that is particulate matter, and ozone, nitrogen dioxide, sulfur dioxide, carbon monoxide, all these things are regulated according to the WHO guidelines. Now, as I earlier told you, and as Deekshana pointed out, the WHO accepted the air quality guideline values. Annual mean value is 2.55 micrograms per cubic meter, but in Sri Lanka it is still 50. So we have to amend these gazettes immediately to be incompatible with the WHO guidelines. Otherwise, although our law or our gazettes treat some quality as healthy or acceptable guideline or acceptable air quality, the WHO, according to the WHO guidelines, it is not acceptable. It is unhealthy. It can cause health hazards. Likewise, even for particulate matter 10, there are annual mean values, 24-hour mean values. given by the WHO, which are very lower than the existing Sri Lankan standards. Even the nitrogen dioxide levels and the ozone levels, sulfur dioxide levels, carbon monoxide levels can be available in the air or atmosphere is drastically reduced. The levels are have been drastically reduced by the World Health Organization, but those levels which are gazetted by the Sri Lankan authorities and the state regulators are still at higher values and not been able to alter or amend to be in line with the WHO guidelines, which is serious, which causes a serious health risk to citizens of this country. Especially the particulated matters are emitted from vehicle exhaust, industrial emissions, burning of biomass and waste, construction dust, forest fires, natural dust and sea spray. Those things are, there are a number of sources, such sources which emit or which creates particulate matters to the atmosphere. And the health effects of PM10 and PM2.5 are also quite different. Now, if we look at the health effects of PM10, that is comparatively larger particulated matters compared to 2.5, these particles can enter the nose, throat, and upper respiratory tract, and it can affect, especially it can give eye irritations in nose and throat, cough, breathing difficulty, worsening of asthma and bronchitis, increase hospital admissions. Those are some of the identified ill effects. Even PM 2.5, that is, those are fine particulate matter compared to 10.5, and sources are identified as vehicle exhaustion, power plants, industrial combustion, burning of wood, coal, and waste. Especially health effects such as heart diseases also can occur: heart attacks, strokes, lung cancer, chronic obstructive pulmonary diseases, reduced lung function in children. Those are some of the ill effects identified by the health sector. Even the Motor Traffic Act number 14 of 1951 gives some controls or exerts some controls of air pollution by prohibiting excessive smoke and vapor. That is, section 207 is the main important section. This controls the air pollution and prohibits the use of motor vehicles that emit excessive smoke, vapor, or fumes. And it empowers authorities to test vehicles and issue regulations on emission limits. And there is a vehicle emission testing system in Sri Lanka. But we all know that system has a lot of failures. Even they temporarily adjust the equipment or the engines to read to give the required reading so that they will, without much hassle, they will obtain the required permission or required permit. But actually speaking, there is no actual control, or actually the air pollution is still in continuance. And section 211 is also very important. And section 164 deals with the road worthiness and vehicle conditions. And section 203, inspection and testing of vehicles. Checks, actually the checking of the vehicles, as I said, is done under section 207 and 211, as I earlier explained. And even there are penalties described and stipulated under the Sri Lankan Motor Traffic Act for air pollution related vehicle offences, such as 224. It deals with the penalties. It says any person guilty of an offence for which no other punishment is expressly provided. There is a 7,500 rupee fine. Actually, it is from 7,500 to 50,000, 15,000. Those are the relevant sections under the Motor Traffic Act. And 215A of the Motor Traffic Act actually was amended in 2017 to enabling sports fines. So that is also one way of controlling the pollutions. But in Sri Lanka, we see that the checking of the vehicle emissions on the road or by the side of the road is not done by the Department of Police due to lack of technical equipments and the instruments required for testing, or lack of training for the police officers or other relevant officials. And even section 195 is also important. When vehicles are unfit for use, it is considered as an offense. And emission certificate requirement is dealt under section 196 of the Motor Traffic Act. And there is another important way of air pollution being committed, that is combustion, open combustion and combustion of plastics. Therefore, under the National Environment Act, and especially National Environmental Prohibition of Open Burning of Refuse and Other Combustible Matters regulations were formulated in 2017. Those are known as Regulations number 1 of 2017, which are published in the Gazette Extraordinary number 2034/36, dated 1st September 2017. And these regulations very clearly says no person shall burn openly or cause to allow or to permit the open burning of refuse or other combustible matters, inclusive of plastics. Therefore, nobody, although we used to practice open burning in most of the areas, it is an offense under the National Environment Act. And this open burning, of course, is done as a result of the failures of the relevant local authorities or relevant urban councils, municipal councils, or times they fail to collect the garbage as the statutory, or they fail to perform their statutory duty, which is compulsory for them to collect and dispose garbage in a healthy manner. And there are emission standards for petrol vehicles. Actually, that is also gazetted. What are the standards that is gazetted under the Gazette number 2079/42 under the National Environmental Air Emissions and Vehicle Importation Standard Regulations. And in addition to that, emission standard for diesel vehicles are also gazetted. It gives what are the NOx, what are the particulated matters, what are the different type of test cycles, then carbon monoxide, how many grams can be emitted for a kilometer. Those things are very clearly described in that particular gazette. Then petrol two-wheeler classification, that means two-wheeler means motorcycle bikes. Those are also classified under this gazette, and different categories, engine categories, then emission standards for the motor bicycles, then 3 wheels are also defined, and emission standards. All these things are gazetted, but these gazetted standards are not tested, because these gazetted standards should be tested on the road. When they are traveling on the road, these gazetted amounts should be tested by the relevant officials. And even for the heavy vehicles and the construction equipments, there are certain limits given by the gazette mentioned herein before. And air pollution also can be dealt under the Code of Criminal Procedure Act, number 15 of 1979, that is under section 98. Magistrate can issue conditional orders to remove nuisances from public places, and especially can stop harmful activities, which are also can be actually observed as air pollution activities. So air pollution activities, if are committed by anybody, it's definitely a public nuisance, because there is no need to find out 5 families, because when the pollutants are added to the air, air is a public property. Therefore, it is deemed to be a public property, any open burning or any pollution of air. Under the penal code also, there are provisions to deal with the air pollution. That is section 261 of the penal code deals with the public nuisance, under which we can deal with the air pollution. And even sometimes there are certain diseases which can be spread through polluted air, right? Even there are air pollution regulations under the quarantine disobedience and quarantine laws, and even making atmosphere noxious to health is also dealt under the Penal Code of Sri Lanka. Therefore, this air pollution now, even if we consider the statutory provisions and the regulations and the gazettes, even so far we have discussed, there are a lot of legal instruments to deal with the air pollution, to curb air pollution, to manage or minimize the air pollution, and to standardize the air pollution. But we are not using those legal instruments and the gazettes or statutory provisions to make our environment healthy, to make air pollution minimize. Therefore, we should study these areas, and we should get the maximum usage out of these statutory provisions. There are some other provisions also under the penal code from 277 to 281 sections. Even poisonous substances. It deals with the poisonous substances. Some air which carries unhealthy particulate matters and unhealthy chemical compounds can be treated as poisonous substance, which can be very easily dealt under the penal code. Even there is a special IGP circular issued by the IGP. The circular number is 1155/94, which empowers the police officers to deal with the air pollution. Right? Any air pollution, the police personnel can deal with and take into cognizance and take the parties into custody, or they can even file litigation or go to courts under the air pollution activities, as there is a circular authorizing each and every police officer to deal with the air pollution. Even there is another law which is very old but is still in force, that is laid down in 1862 during the British rule, that is the nuisance ordinance. It also deals with the air pollution. And especially section 2, section 5, section 6, section 17 deals with the air pollution and pollutions control. Then the Municipal Council Ordinance number 29 of 1947 is also very important, and functions of the Municipal Council also includes to minimize the public health risk, right? They under the section number 4, they are in control and administration of all matters relating to the public health. Therefore, they have the power. And under section 96, Municipal Council is to be the general public health authority during the area. Therefore, Municipal Council has a major role to play in minimizing the air pollution. And even collecting of refuse and duty of control to conserve the scavenging, to maintain the scavenging activities and the collect garbage and remove all street refuse is also important, because these if these powers are not, or the duties are not properly performed by the local bodies, then people tend to engage in open burning to get rid of these waste and the garbage. Even under the Municipal Council Ordinance 136A is very important. It empowers the municipal councils to deal with the pollution caused by the factories. Therefore, the municipal council can directly institute legal proceedings against the polluters under the 136A of the Municipal Council Ordinance. And even under section 272, the Municipal Council can make bylaws relating to the public health and sanitations, but most of our local bodies, they have failed to issue or prepare bylaws in relation to mitigation of air pollution. And Urban Council Ordinance also, there are a number of provisions and the number of sections to deal with the air pollution matters. One section is 103, that is Urban Council to be the public health authority. Then section 35, 36, 153, 157. All these are especially very important, and it has the powers to control open burning of waste, which is a major source of urban air pollution. And even under 126, they have the power to inspection of nuisances. Under that, they can go and inspect where the illegal burnings are taken place. And even 127D is also important. Pradeshi Sabha Act is another important act. Under the Pradeshi Sabha Act, section 106, 78, those are very important sections. And section 100, 93, 94, 95, 122, even Pradeshi Sabha also can prepare bylaws, right? General powers are also there to deal with the air pollution. Those are very significant and important. Even the judiciary has taken very important steps to mitigate air pollution. Even under the precautionary principle, there are, when there is an application under the precautionary principle to deal with any place where air pollution is taking place, the court will have to take steps. Now, even in one of my cases, I filed the case citing that there is a pollution caused by a small industry. As a result of air pollution, a small child was severely actually affected, and there was a lung disease caused on this particular child as a result of this air pollution. Therefore, I could get a restraining order under the precautionary principle from the Supreme Court. And even there is a case still going on to mitigate the air pollution, especially that is a case filed by Dr. Umasugi, that is writ 459/25. This is especially mitigate the Jaffna air pollution. And court has already issued orders against the Jaffna Municipal Council and the Central Environment Authority to prepare reports and submit prepare reports and the mitigate containing the mitigatory measures that they are going to take, and they have already taken, and submit those reports to the court. Therefore, Sri Lankan judiciary is also now progressively upholding the precautionary principle and especially prepare to deal with the air pollution issues. Even right to healthy environment is also one of the most important thing. But before that, the polluter pays principle is also there. That is emanated from the principle 16 of the Rio Declaration. And under that, the person who was engaged in the polluting of the air should be held liable to the damages caused by his activity. Therefore, there are environmental economists who can calculate the damage using modern techniques, so that polluter pays principle can be applied. Now, in Sri Lanka also, polluter pays principle was applied in number of cases. So even recently, the Express Pearl matter, by applying the polluter pays principle, the court directed the respondents to pay $1 billion as an initial payment. And there are international case laws also which dealt the polluter pays principle, especially under the air pollution issues and various other pollution issues. And therefore, the judiciary is taking care of the air pollution issues if we can present a good case to the judiciary or to the courts. And the UN General Assembly also has taken a number of proactive measures. And in 2022, there was a resolution passed in the UN General Assembly recognizing the right to clean, healthy, and sustainable environment. Therefore, as a result of passing this resolution, now each and every government is duty bound to create an environment which is clean, healthy, and sustainable for the human beings and the other living beings. Therefore, even in court cases, we can use this UN resolution and force the government entities to commit or to perform their statutory duties to mitigate pollution and the air pollution. Even Seychelles Court of Appeal in 2024, actually, this was a pronouncement by our Supreme Court Justice, His Lordship Justice Janak Silva. Right to healthy environment is now recognized as a fundamental right. Therefore, nobody is permitted to pollute our environment. When right to healthy environment is treated as a fundamental right, it is now recognized as fundamental rights under a number of cases. Therefore, nobody is permitted to pollute our environment. Those are also very important court decisions. Now we have to take the issues to the court and we have to actually mobilize the courts to improve improve the standards, or expand the scope of the healthy environment and scope of the uh, mitigation of air pollutions. So even the climate change, which we are experiencing now, even recently we experienced DITWA and various other weather hazards. All the experts are of the view that these unacceptable weather patterns or weather hazards are occurred as a result of climate change. Actually, the climate change is greatly induced by the air pollution. Air pollution by various gaseous compounds which damage the ozone layer, as well as carbon dioxide and various other gases which uh, creates the greenhouse gas effects, or increase the greenhouse gas emissions and the carbon footprint. Therefore, the air pollution is a very important thing to be looked into. And even there are a lot of legal instruments. There are a lot of statutory provisions, regulations, and the case laws to deal with air pollution. We should be aware of it, and we should utilize those things in court. And even the future generation should be educated, and their rights also should be upheld and protected by us. And we should contribute our knowledge to protect the rights of the present and future generations. Thank you.
Thank you very much. It was indeed very much thought-provoking. I didn't want to disturb you and break the flow, because you were presenting some vital factors referring to the legislative provisions as well as judicial activism. I wonder whether, so in your opinion, if we look at the Indian laws with regard to the air pollution, I happen to come across one legislation, that is Air Prevention and Control of Pollution Act of 1981. Don't you think now you happen to refer to several provisions and acts where in the Sri Lankan context they happen to regulate the air quality, etc. Don't you think if we are to enact one piece of legislation like what we see in India, would that be much more efficient when it comes to putting that into practice? So, in your opinion?
Yes, Theekshana, it's a very good question and very good opinion, actually. Even as I mentioned, there is no specific laws specifically focusing on air pollution, because under the National Environment Act, it is only a small part. Under Penal Code, it's only a small part. Under the Criminal Procedure Code, it's only a small part. Under the Municipal Council Law, Urban Council Law, Pradeshika Sabha Ordinance, it's a small part. There are some gazettes issued, but under the National Environment Act and Motor Traffic Act. But even the Motor Traffic Act, that is a small part. By taking all these different sections and the portions contained in different legislations and the statutes and the gazettes, we can prepare. We should actually prepare, as suggested by you, some specific legislations or statutes specifically dealing with the air pollution issues, as done in India as far back as in 1981. Even that was done in India more than 45 years ago. But in Sri Lanka, still we have failed to prepare such legislation. Therefore, I think it is one of the most important thing, because we as a country is spending a large amounts of money, colossal amounts of money to deal with the lung diseases and the various other diseases caused to the public as a result of air pollution. And the lung cancers, those things are very common nowadays, but we should focus on these areas and we should prepare such legislation. That's a very good idea, I think.
Thank you, sir. Thank you very much. And also, when I was in fact researching, I happened to come across a lot of case laws where, and even cases filed by you. So I would say it's high time, as you mentioned, that in fact you can take the initiative, because one would figure out in the long run that the quality of AI is a fundamental aspect in one's life. So I would suggest humbly that it's high time, led by you, we all take that initiative where we look at one piece of legislation than having pieces here and there, so that it becomes practically impossible to give effect to those regulations in a timely and a practical manner. Also, I was wondering, sir, when it comes to doctrine of public trust, we happen to see whenever we file an action, uh, we happen to see more of a approach where we try to restrict or restrain the state and the respective authorities. Don't you think when it comes to maintaining the quality of air and the ancillary factors, wouldn't it be possible for us, for the legal fraternity in particular, to use that tool, the doctrine of public trust, as a tool where we can give effect to a positive obligation on the part of the state and the respective authorities?
That is also a very good idea, Deekshanan, because we know that air or atmosphere is something owned by the all human beings, future, present and future, and not only by the human beings, but all living beings. And it's a public property, but not limited to one country, right? Even the birds and various other insects which are found in our atmosphere or which are found around us, their rights also should be treated. The rights of other countries, because when a particular place on the earth is polluted, it is circulated around the earth. Sometimes we are also suffering from the pollution caused by some other countries. Therefore, we have a very sacred duty to protect these common resources, because it affects others. It affects future generations. Sometimes when we pollute air here, sometimes it may circulated in the atmosphere. It may get circulated and sometimes remain in the atmosphere for years, sometimes for decades. So therefore, we have to be very careful as public, and we have to raise these issues, and we have to actually emphasize these concerns when cases are filed and cases are taken up, especially in relation to air pollution.
Also, sir, I would like to raise this aspect of state sovereignty with the current situation in the region. For an example, the situation in India, because we happen to every now and then experience the hardships posed through the air pollution taking place, in particular in the southern Indian parts. In your opinion, would it be? I understand it's not an easy task going ahead with the diplomatic relations and all, given the magnitude of the countries and all compared to that of us. don't you think with the help of customary international law and with the state sovereignty, that it would be high time for us to look into that aspects also, for an example, to see how we can have a lesser impact from the regional air pollution, in particular with the example of India?
Thank you, Deekshana. That is also one of the most important thing, because there are certain regional organizations, especially to look into the well-being of the South Indian region, and especially there are some regional bodies to deal with the Asian countries, and in addition to that, there are international bodies and international especially organizations to deal with the international requirements. First of all, I think we as a country should take some diplomatic initiatives to deal with regional countries, especially to mitigate air pollution in their country, as well as while seeking the help, while instituting the discussions, or while commencing the discussion, we can't request the other countries to mitigate air pollution without we taking adequate steps. That is one of the most important things to bear in mind, because we as a country have not taken adequate steps. Therefore, I don't think that we as a country can request from other countries to deal with the issue. But first of all, as a country, each and every country, even including the Sri Lanka, should take initiatives within their to curb or to mitigate air pollution within their territories. Otherwise, we now, for example, if we as a country is going to wait without taking any precautionary measures and keep on blaming India or other regional countries, if the other countries of the region also start doing the same thing, there will be never end to the issue, or there will be never end to the air pollution issue. First of all, that means we should, as a country, we should practice and then request the other countries to practice. And even we can mobilize the international bodies such as UN and International Court of Justice and various other international bodies also to make pronouncements to be which are applicable, which can be bound all international bodies, all countries, right? To especially the treaties or the orders or pronouncement which bind or which have the effect of binding the countries, regions, and especially in relation to the mitigation of air pollution. Now, recently, we know that International Court of Justice issued an advisory opinion about climate change mitigation obligations of each and every country. Likewise, if International Court of Justice can issue another advisory opinion or binding opinion of each and every country, which bounds each and every country on air pollution mitigation, and we can mobilize, or a few countries which are affected can mobilize, that also will be a great initiative.
So I'm sure our viewers must be waiting to throw questions at you. But before moving on to that, I would like to have a couple of more questions thrown at you, and then to have some clarifications. For an example, I was wondering if you can clarify to our viewers. It's often understood that when it comes to environment and projects, environmental protection license, or that's EPL, and environmental impact assessment EIA, they play a vital role. And my understanding is day before the Jaffna Cricket Stadium was where the developments were asked to be stayed, given that the EIA is not in place. So in your opinion, when it comes to air quality control, what kind of a impact these kind of APL and EIA can have on the regulation of the air quality going beyond the regulations which are in place?
That is also a very good question, Deekshana. Now, any industry which emits air as a byproduct of their activities has to obtain permission or permit to exhaust air as a result of as a byproduct under the National Environment Act, and these air qualities are checked by the relevant authorities, or should be checked by the relevant authorities before granting permission. And even some large-scale projects such as Norwich Chole or any other such large-scale projects which emit considerable amount of pollutants to the atmosphere should undergo. There are certain limits and the nature of the industry according to the EIA gazettes. There are gazettes which require some projects to go through EIA process. That EIA is the Environment Impact Assessment Project, that is under Gazette number 772/22, which is issued under the National Environment Act. And likewise, there are certain criteria, different criteria under which the permissions can be granted and permits are issued. But most important thing, Deekshana, there is no proper monitoring mechanism. Anybody can obtain a permit or license, or can get the permission under the EIA process by preparing a document or preparing a project report, or just performing a test. But after these tests are done, after these projects reports are approved, who is going to monitor it? That is the most important thing, because in Sri Lanka, the monitoring of industries, especially the air pollution, is actually hopeless, I must say. It is not done, and most of these licensing issuing authorities have just become clerks of issuing licenses and permits. So we have to compel, we have to actually formulate a mechanism of conducting recurrent test and periodical test for all these industries which has obtained or which have obtained permits and licenses to emit pollutants under standard or standardized regulations.
Thank you, sir. Before I open the floor to our viewers, one final question would be, now, I'm sure you must be much conversant with what happens at the ground level when it comes when we try to give effect to these rules and regulations, where there would be selective prosecution, and when it comes to certain individuals, there won't be any effective, the mechanism won't be applicable per se, especially in the corporate sector. So don't you think, sir, that concepts like I have come across in the international context, concepts like pollution taxes and cap and trade market concept, where they, and also strict liability framework, where you can't escape from the reality. Don't you think those would be more timely given the historical experience you happen to experience, sir?
Yes, now as you correctly says, there should be some new tools actually should be introduced, and the internationally acceptable tools, and especially now we know that the world is moving towards calculating carbon footprints. Even some of the products produced by some industries are not exported or not accepted as accepted by some of the countries and some of the buyers, if the carbon footprint of those products are high. Now that culture has to be developed internationally as well as local, and carbon budgets and carbon assessment of carbon and carbon audits especially are performed in some countries in a lot of industries and for a lot of industries, but it is done only for one or two industries in Sri Lanka. But that should be the practice and the culture that we should develop, because if we conduct carbon audits and for industries and activities, then through those audits we can find out how much pollutants are added to the environment, and what is the nature of the damage each and industry and activity cause into the environment, and how they should be liable, and what are the precautionary measures they should take in order to meet with the international standards.
So thank you so much. It was indeed very much thought-provoking, and as we all know, we get to learn something new from you every day, because you keep fighting, and there's no end to that fighting, and we are very much grateful to that. And now I'm sure our viewers are pretty much eager to ask questions from you and get clarifications, and I apologize if I took their time. So I would like to invite our viewers to ask questions and have clarifications from our esteemed guest, Dr. Ravindranath Dabare.
It seems that there are no questions.
Maybe so they are too much enthusiastic about the environment, and so that they keep thinking as to what to be thrown at you. In the meantime, I was just wondering, in fact, I was lucky to be, of course, opposed to you in one of the Supreme Court cases. This is with regard to the famous Pavala matter, and I'm sure it would end up in a wonderful judgment in the long run, probably within this year. So I'm privileged to be a part of that case where it speaks volumes of. In fact, it goes beyond air pollution and all these things. It's more into these phosphate and all these minerals. I would like to, before I hope you got another couple of minutes, or rather 5 to 7 minutes before we end the proceedings. If you would be, I'd be grateful if you can, in fact, share some of your personal experience through these cases, in particular ITS and FRs, if there's any which you can highlight to our viewers.
Actually, thank you very much, Deekshan, because there is no need something, even the lawyers, the attorneys at laws who are taking part or joining this, who has joined this program, they might think that most of the case laws are based on the cases instituted in Supreme Court and the Court of Appeal. The air pollution mitigation can only be done through Court of Appeal or Supreme Court, but that is a myth. Even there are a lot of provisions that can be implemented and that can be instituted in magistrate court now, even for our lawyers, budding lawyers and upcoming lawyers, and they can do wonders if they can use Section 98 of the Criminal Procedure Code, because under the public nuisance, most of the air pollution issues can be dealt with, and air pollution is definitely a public nuisance, and we don't need to have 5 families or number of families to prove that this is a there is a public nuisance, because air is treated as a public property. And if we can prove that something is emitted, something which can cause pollution, something which can cause irritation, something which can harm the environment and harm the public health is emitted or exhausted by that activity, then there is a case, or there is a case to be instituted in the magistrate court. Magistrate court being the nearest court to you and I, even in the magistrate court, even without going to other provisions that I mentioned, even at least through public nuisance provisions, we can do wonders. But our attorneys at laws, and especially the law students and even the public, should be capable of utilizing these provisions actually in order to define the public nuisance widely, and especially to incorporate air pollution issues, because in addition to that, each and every one should bear in mind, or to actually we should commit ourselves to mitigation of air pollution, because the air is one of the most important resource and precious resource that we have, because we have to breathe in, and actually the breathe is one of the most important thing that which makes all of us alive. We know that nobody can't live more than few minutes if his breath is obstructed, if air is polluted. Even the polluted air inhaling can lead to death. Therefore, air pollution is a very serious thing to be think of, and even the relevant regulations and the statutory provisions has to be carefully dealt, should be carefully dealt, and should be carefully considered and improved. And actually, the air, especially air, we should respect our air, because the air is the most important thing which keeps us alive. Not only us, all the living beings, even the trees and other living beings are highly depending on the air. Therefore, air should be treated as a precious thing, and we should strive hard to protect it for the sake of our lives, as well as the lives of the future generation.
So I must apologize. There have been a couple of questions in the Q&A box. If I may be permitted to.
You can take.
The first question is there a special regulation related to the IDB zones air pollution from its factories? That would be the first question.
IDB means industrial development.
My understanding is that, sir, I think if Taranga Mudita Kumar, if a clarification can be sent, I think what is meant by that.
Because there are two categories, because the urban and the residential areas, residential areas, certain standards are different to the industrial areas. But my view, legally that is correct, because there are industrial zones. In those industrial zones, there is tolerance is comparatively high. But my view, the air cannot be separated from industrial zones to urban area or residential area. Therefore, air is mixed continuously mixed from here and there. Therefore, there should be one standard for the whole world, and that should be the standard accepted by the World Health Organization. But unfortunately, to promote some industries, actually speaking, there are differences in industrial zones regulations as well as the regulations applicable to residential areas.
Thank you, sir. There has been a clarification that it has been industrial with related to industrial zones, and I hope it answered your question, Taranga Kumara. Thank you for the question, and moving on to the next one. We got an anonymous attendee where there's a comment. Thank you, sir, for the very comprehensive presentation. Would you be kind enough to share a few case examples on the recognition of the fundamental right to a healthy environment in Sri Lanka? Also, would you be willing to share your comprehensive presentation with us? A good question, sir.
Yeah, actually, I prepared a presentation. It contains 55 slides. I have shared it with Teekshana. If Teekshana can share it with the participants, I don't mind. Anybody can use it. But unfortunately, I am not using there was a sudden technical issue in my normal equipment. Now I am using some equipment which is not familiar to me. Therefore, I can't. I don't. Actually, I am not aware. I am not so technically sound person. I don't know how to share it. But I have already shared it with the even there is an updated presentation I can share with Teekshana. There are some, but even what I have shared with Teekshana, you are entitled, you are permitted to share. And the first part of the question, there are a number of case laws under the in the Sri Lankan judiciary also. Right to healthy environment is guaranteed. Even Eppavala case. And even after that, there are a number of cases. Right to healthy environment is guaranteed, which are pronounced by the Supreme Court and the Court of Appeal. Even the recent judgment that I stated is the judgment of Justice, His Lordship Justice Janaksa Silva, that is in that also right to healthy environment is treated as a fundamental right. That is the most important thing. In other cases, it is treated as only a right, but in this case, it is treated as a fundamental right. Then we can invoke the fundamental right jurisdiction when right to healthy environment is affected. And even now, anyway, Universal Declaration in 2022, which we can use even without case laws to actually get the authorities or the state authorities to abide by it, because there is a resolution accepted by all the countries, and even we ratified it, that right to healthy environment is a universal right of and which should give effect by all the nations, all the member nations of the United Nations.
Thank you, sir, for being that generous. I'll take steps to share the presentation with the respective viewers. We got a couple of more questions. One from, I hope I correctly pronounced the name, Madhumita Karunanandan. Hi, sir. Thank you for this insightful session. Next question is, vehicle emissions and open waste burning are still major contributors to air pollution. Which policy change would create the fastest improvement in reducing these local sources? Thank you, sir.
Now I shared the updated. Now I shared you the updated presentation through WhatsApp. If you can share that, because there were some corrections in the previous one.
Thank you, sir. I mean, receipt of the same. I'll take steps to share the same with them. we keep getting more and more questions. If I may rephrase the question, the last question, that was vehicle emissions and open waste burning are still major contributors to air pollution. Which policy change would create the fastest improvement in reducing these? I hope the question is contributory factors.
Is there a question or idea?
That's of course a question asked. If the question would be as to what would be the policy change that would reduce the vehicle emissions and open waste burning.
No, the policy change should be the continuous monitoring and continuous checking, because although there are standards laid down in the books and the statutes, actually it doesn't worth the paper on which it is printed if the continuous monitoring and continuous checking is not done by the authorities. Then even the most of the pollution is created and generated by the state vehicles. Now, if you observe the road, there are a lot of state vehicles which emit a lot of pollutants. So the policy change should be the continuous monitoring and continuous checking.
Thank you, sir. To add to that, there's one more follow-up question by Darshana Jayawardena, if I may take a couple of minutes of your time. The Sri Lanka has air pollution minimization policy related to CTB buses and other public transportation. Interesting question, because I don't think that they do not properly pass the echo test in terms of air pollution. The question is with reference to whether there's a specific policy with regard to public transportation in particular, sir.
No, there is no specific policy, but normally the government vehicles are not checked for even vehicle emission test reports by the police and even issuing these things required permits and the licenses. Therefore, those each and every vehicle, whether it's owned by the government or maintained by the government or the members of the public, should be treated as equally, because air pollution is something which we have to deal with very carefully. As I very specifically stated, there is a colossal amount of money spent on lung diseases, especially treating lung diseases, and actually the mitigation of the lung diseases. So we can, there are a number of patients, if we find out the figures and the statistics with lung diseases, even from very small childs.
Thank you, sir. I may be permitted to have two final questions asked so that everyone is happy. One question would be, with Sri Lanka and many global South countries moving towards renewable and clean energy, what legal and policy shifts do you think are most critical to ensure this transition, which should genuinely reduce air pollution, sir? That's the question.
Actually, a lot of countries, as you said, is moving towards the renewable energy, especially in relation to the power generation, as well as the transportation. Those are the two major sectors which affects the global warming. But air pollution is not limited to those two areas. Air pollution is being contributed by open burning, as well as transportation and industries. Therefore, if we can, on our level, especially transportation and energy sector, policy reforms has to be taken by the government. But we, of course, as society, we can inform others if they are engaged, even our neighbors and our relatives, even our family members, if they are engaged in open burning, to prevent it. And if the relevant local authorities are not taking adequate measures to collecting garbage, we can pressurize them. Even we can file cases against below and local authorities, and even as a country now, we should specifically especially as based on the question posed to me, we should take policy measures and policy directives to get rid of fossil fuels, especially in the power generation and energy sector, as well as we should, as a country, promote especially solar energy and other renewable energies available to us without damaging the environment. Now, say some of the renewable energy projects, such as mini hydro, which can cause irreversible damage on the environment, has to be think twice. But solar projects and things like that has to be actually taken care of it and promoted, and more facilities to be provided, and especially the smart grids should be our target, and the storing of renewable energy facilities has to be promoted, and especially the technology has to be improved. Therefore, we can have a society or environment with less environmental pollution, because nowadays we know that some country, we have, even as a country, we have committed ourselves to reduce fossil fuels. Now, as a country, we know that we have commitments to the UNFCCC. UNFCCC is the United Nations Framework Convention of the Climate Change. So, as a country, we have committed to reduce greenhouse gases as a country. So we have to stick to those commitments and take adequate steps to fulfill these commitments.
Thank you so much. The final question to end the webinar, today's webinar, and I'm sure this would be the ideal question, and the answer to this would encourage many. The question is, as young lawyers stepping into environmental law, what message or advice would you like to share with us as we begin our journey in this field?
Actually, thank you very much for that question, because now I am also faced with a problem, because there are very few, or there are actually no attorneys at laws to take on our mission when we now we are getting old and we have to leave this world. There should be a new generation to take the baton, because when we came into the environmental law in 3 decades, before 3 decades, environmental law was not a subject in any of the institutions in Sri Lanka, and we even I myself, I had to personally visit the museum to find out some of the gazettes relating to the environmental law. So we studied environmental law on our own, and we actually created a new path. Even Mr. Gunawardana, we must be thankful, because he is a little bit senior to me, and he also was doing a lot of things. Now, as he prevented from litigation activities, I had to take over the litigation activities mostly, and I have already engaged more than 600 environmental litigations, and there are about 70 odd ongoing litigations. But I think what is my feeling is we are depending on the environment. As I said, we are depending on the air, we are depending on the water, we are depending on the food provided by the environment. So as lawyers, what are we doing? What are we contributing to protect the environment? Although we are depending heavily on the environment, as lawyers, we are not taking care of it. But we have a duty. We have a duty as lawyers, attorneys at laws. We are not only expected to earn money and fill the pockets. We have some duty to protect our environment, which is precious, and which is enormously contributing to well-being of all living beings for a large number of years and even future. It has to be protected. So if lawyers are not coming forward to do that, then it will be the pollutants and the environmental destroyers who will come forward and destroy the environment, and there will be no future, no world to be stepped in by our future generation. Therefore, we have a duty. So, in fulfilling our duty, we have to at least do few cases in environmental litigation, and then at the end of our life, we can be satisfied that we have done something to the mother. We have been grateful for the air we breathe in. We have been grateful for the water we consume. We have been grateful for the environment which provide us food and other requirements such as medicine and things like that. Therefore, we have to be grateful as human beings to the environment. So, in keeping with that gratefulness, we as lawyers, I think, should contribute at least something for the environmental protection through environmental litigation. If anybody is interested, I can be I can help according to the knowledge and the capabilities I have. But this area is a very wide area if we look at the international standards. Thank you for that question.
So thank you so much, and I'm sure that final answer, or rather the message, would echo in our minds for years to come, and an important message where we would pause to think twice. Thank you so much, sir. It was indeed a privilege on my part to be moderating this session where we consider you a legend in this field. And also I would like to thank on behalf of the Bar Association of Sri Lanka for your valuable contribution and time spent on us and this knowledge shared with our viewers. So with that note in our mind, thank you so much. Thank you. It's indeed a privilege. I would like to have Rochelle on board so we can conclude today's proceedings. Thank you again, sir.
Thank you, Tikshana. This brings us to the conclusion of the 17th webinar and episode 35 of the Basics of Law webinar series, organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. On behalf of the Bar Association of Sri Lanka, I extend my sincere gratitude to our esteemed resource person, Dr. Rabindranath Dabare, and our moderator for today's session, Mr. Tikshana Patirana, for an insightful and engaging discussion, and for generously sharing their valuable knowledge and expertise with us. I also wish to place on record my appreciation to the Webinars and Legal Symposiums Committee of the BSL for their dedication and hard work in organizing this informative webinar. Finally, I thank all the participants who joined us with this evening and contributed to the success of today's program. Thank you once again. I wish you all a very pleasant evening. Good night.
Good night.
Thank you. Good night.
Thank you. Good night.